and make much better arguments. I was restricted in my page limitation number, so I would, to the extent that those legal arguments are out there, I don't know if the court would consider having their staff or judicial attorneys review those as well, but I would ask the court to consider that because there are a lot more information pertaining to this, facts of this, well, more so to the generalities of the HIV virus and medical advances made over the years.
So you're saying their arguments are more fleshed out in those
Yes,
cases?
most definitely. There's the American Civil Liberties Union and some other organizations have filed extensive briefs in those cases that go into medical studies that essentially show that HIV is, when it originated back in 1981, it was essentially a death sentence for those people that had it, that contracted that virus. Now with proper medication and treatment, people have life expectancies. If you're diagnosed in their 20s, they can live to be in their mid to late 70s is where the medical journals indicate.
And counsel, you know, as the presiding judge, and I would obviously speak with the panel in regards to this, but it's never been our practice. We can't consider things that are not in this particular case. Obviously, we look at the precedents from the case law and the statute and all those type of things, but amicus briefs from other entities and so forth that are not filed in this particular case, I'm not sure that we can look at those. However, you did make the argument, what you're making now. You may not have had as much support for it, but you did make the argument you're making now. And basically, so what you're saying is that, you know, that the statute is not really even necessary anymore. The whole purpose behind it is not the same as it was.
Well, that is the argument to the extent that there's no constitutionally justifiable basis for treating carriers of the HIV any differently than carrying or treating carriers of any other sexual transmitted diseases. It's no longer a death sentence. I mean, you know, whether you have gonorrhea or herpes or some other, or hepatitis C, for example, it is actually potentially as deadly, if not more deadly, than HIV today, is that I guess the point I would make. For purposes of the arguments that I set forth, which I guess are in a condensed version than what exists pending in front of the Supreme Court. The other thing I wanted to mention real quick before I get into that was I have the initial hurdle of trying to convince this court that it's plain error not to address the constitutionality of it. What actually happened in this case was Mr. Boatright's first attorney, court-appointed attorney, got suspended for an infraction, and then Attorney Pat Summers got appointed late in the game, and then Pat took over, or Attorney Summers took over the case, went to jury trial in front of Judge Kimbler, and that issue was just never raised. I had to make an ineffective assistance of counsel argument in order to support my plain error argument. So recognizing that I would ask the court to address that assignment of error, the court does have to acknowledge or find that it was plain error not to raise it in the trial court. And then I go into why it is a violation of the Equal Protection Clause under the 14th Amendment, because the argument is that HIV people are treated differently than those with other communicable diseases, and that the statute is not reasonably or rationally related to a legitimate state interest. And this is where you get into the law review articles, some of which I cited in my brief that are better explained in the State v. Batista case. Our argument is that the criminalization of failure to notify, in fact, does not reduce the rate of HIV infection, and that is the law review article cited on page 19 of the brief. Essentially, this statute as it exists reinforces and perpetuates an outdated HIV stigma, given the medical advances in the HIV field. I also would contend that the statute is arbitrary and over-inclusive, as it fails to distinguish among forms of sexual conduct that have wildly different rates of transmission. And without getting too graphic, I'm referring to oral sex versus other forms of penetration. Medical studies, again, indicate that some sexual activity or acts are less likely to transmit the HIV virus than others. And that, again, is from a medical article that's cited on page 19 of the appellant's brief. And
Is that like accepted? A lot of times these studies can be, you can find a study saying one thing, another study saying the other. It almost seems.
well, see, that's what was kind of interesting about this case, because if you go back into the original indictment, he was charged under 2903A1 of the revised code, and then right at the day of the trial, I believe the state orally amended to B2 to eliminate that issue, because Mr. Boatright had an expert witness that was going to testify with that kind of information. So the state, basically, by amending it to B1, took that issue off the table.
What would you have to say to the argument that this is still an uncurable
Well,
disease?
we would, for purposes of this argument, we certainly stipulate that the state of Ohio has a legitimate state interest in preventing the spread of HIV virus, and that it is, as far as I know, the medical community would agree that it is an incurable disease, but I think you could say that about herpes or hepatitis C or gonorrhea too. Well, maybe not. Maybe I don't know.
And we don't
about
have all
that.
this information necessarily within our record, but I think an argument could be made that those diseases don't really affect your life expectancy, and if you're not treated immediately, as would be with HIV, there could be different outcomes.
Again, I'm an attorney, not a medical
And
doctor,
this
and
is
I was
not a record.
limited in how
And
much
this is not a
information I
record,
could
too.
provide the court. I'm not disagreeing with you, but that actually overflows into one of my next arguments, where the criminalization of this type of activity is actually directly at odds with the legitimate government interest of protecting public health and encouraging those people at risk of HIV to get tested and seek treatment. Because under the statute, if an individual avoids testing and this remains ignorant of his medical condition, he can't be prosecuted under the statute, because it's under B1, they say you have to have actual knowledge, and that is basically, I think, assignment of errors number 2, 3, and 4. I'm not going to rehash. I put 17 pages of kind of I don't know how long the transcript was, but I tried to get as much in there. I'm not going to argue who said what during this case. It's in the record, it's in the brief, so you can decide whether or not the jury lost its way or it's against the manifest weight of the evidence. I did my best to try and lay it out from Mr. Boatright's perspective, and obviously the state has a different interpretation. But that was one of the reasons why we believe that the statute is unconstitutional, because people, if they are diagnosed with HIV, they have fear of being harassed, they may be discriminated against at their job, they may lose their health insurance. There's really not a compelling reason for somebody to get tested.
How about life?
Well, if admittedly they're
your point.
engaging in high-risk activities, whether it's sexual related or intravenous drug use with needles, but if you put a statute out there that says if you know you have this disease and you're going to be criminally prosecuted, not just, potentially a 2 to 8 year sentence, it's treated people differently than, let's say I had hepatitis C and I didn't tell a victim or a partner of mine that I had hepatitis C and I passed it through sexual conduct. I wouldn't be charged under this statute. Maybe, this statute is specifically tailored to the HIV virus, and I think that's where you get into an equal protection argument, that it's treating HIV infected people differently than people with other similar medical conditions or communicable diseases, however you want to phrase it.
And counsel, you're in your rebuttal time if you want to say that.
Oh,
or you wanna
well,
proceed.
just real quick, there's also an argument advanced that it violates the free speech clause of the First Amendment. And there's also the third argument under that is it violates prohibitions against discrimination on basis of disability, because I believe HIV positive people have been legally diagnosed or classified, is a better word, as disabled people under both the American Disabilities Act and Section 504 of the Rehabilitation Act. The only thing I want to add real quick is I wanted to mention something about assignment of error number 5, which was the jury instruction that dealt with whether there was a definition under OJER or OJI as to knowledge versus knowingly. That was, it's in the transcript where Attorney Summers tried to get the knowledge definition as contained in Webster's dictionary. Judge Kimbler declined to go that route. Defense counsel timely objected. He gave the knowingly jury instruction, and I set out just a 1 or 2 page argument in the brief that I'm not, because of time limitations now, I'm not going to reiterate it, but I'd ask you to consider that assignment of error as well.
Thank you.
And I'll reserve the balance for rebuttal.
Thank you.
May it please the court, Helen D. Martino on behalf of the state of Ohio, the appellee, we are asking that this court affirm Mr. Boatright's convictions for felonious assault in violation of subsection B of Revised Code 290311. With regard to the first assignment of error, alleging that there is an unconstitutional aspect to this statute, the state would argue that this statute, because it relates to persons who have HIV or AIDS, that is something that would be examined under a rational basis test, that this statute is rationally related to the legitimate government interest of preventing, stopping the spread of HIV. This disease is clearly different than other sexually transmitted diseases. Other courts that have examined statutes that differentiate between HIV, AIDS, and other statutes distinguishing with other sexually transmitted diseases have said that those do not violate the Equal Protection Clause of the Constitution.
I have a question.
Yes, Your Honor.
You're looking at other diseases, all right, if you're talking about gonorrhea, syphilis, we know you could take an antibiotic, but what about something like HPV? It's not curable, and I think, again, I'm not a doctor, that statistically, it really, really increases the rate of ovarian cancer in women, which is not detectable and deadly. But yet, people who know they have HPV aren't compelled to tell someone they have it. What's the difference?
Well, I think, one, HPV is something that is much newer in the medical community. And two, I don't think that it has as great of a, the lethality of it, even though there are new medications, and even though the lethality rate perhaps is lower with HIV now than it was in other countries, it's not the same. HIV and HPV are just, I think they're still treated medically different. There's an argument to add HPV to the statute, but I don't think that would be an argument to take HIV/AIDS out of the statute. Clearly, what the government is, and when he was talking about there's no compelling interest, the fact is that folks who get sick that don't get tested for HIV, then they can't, get the treatment for themselves. They may have intercourse with other people and spread it, maybe not intentionally, because they didn't know they were sick. So clearly the government has a legitimate interest in helping the people who have the disease to get the medication. We know that if it is caught early and treated early, you do have a longer ability to stay healthy. It's not going to be cured, but at least you may be able to live many more years than you would have if you did not get the treatment. And it will help the people, not just the person who has the disease, but the other people in the community as well. And two, this statute does not penalize you for having a positive HIV test result. This statute penalizes you for having the disease, knowing you have the disease, and then knowingly engaging in sexual conduct with somebody else without telling them. And that is, the aspect of it that makes it a criminal issue. So the issues with the ADA or the other arguments that were raised by opposing counsel really don't have anything to do with whether this statute has a rational basis for focusing on people, that class of people who have HIV or AIDS. So therefore, we would argue that, one, that there is a presumption that a statute is constitutional. Two, there is no court that has held that this statute is unconstitutional at this time. Courts that have examined this issue have said that there is a legitimate government purpose and that it's rationally related. Also, if this court were to affirm the decision of the trial court, the appellant could, of course, appeal to the Supreme Court, and they could hold it in with Batista and then see whether or not the Batista decision, when it comes out, will be relevant to Boatright. He did not preserve the issue below, so this court, if you find that in fact it was preserved, then the Supreme Court would decide also whether that was accurate, that it was preserved, and then decide whether Batista is even relevant to Boatright's case. The state would argue that he hasn't, in fact, preserved that issue, and therefore he would be outside the scope of the Batista decision when it comes out anyway. With regard to the argument that this violates his First Amendment right to speech, the state would argue that that would be examined under strict scrutiny and that this statute is narrowly tailored to promote the compelling state interest of preventing the spread of an incurable infectious disease, which is HIV. The state would also argue with regard to the jury instruction. The court gave the OJI instruction unknowingly. There's no case law, nothing to support the appellant's argument that the court abuses discretion by following the letter of the law as set forth in OJI as opposed to the Webster Dictionary definition of knowingly, and the state would ask that this court overrule that assignment of error. Just briefly to get into the manifest weight and the sufficiency of this case, once you get past the constitutional hurdle, this is exactly the type of case that supports the need for the B section of the statute. This was an individual who knew he had HIV. He knew that he was sick as far back as 2011 when he attempted to donate plasma. He was told he wasn't able to donate plasma. He disputed some of the content of the conversations that he had with two of the individuals who testified from CSL Plasma, but he did not deny that he was told that he was unsuitable to give blood again, based on the fact that he was notified twice about the HIV, based on the fact that the two people who testified from CSL said that he was notified in writing and orally that he had HIV. It's clear from the record that Mr. Boatright knew that he had HIV and that he had unprotected oral and anal sex with another person who then contracted the disease, which is exactly the reason why we have this statute in place, is to prevent individuals who know that they have HIV to have intercourse with other people without telling them about it. In this case, the victim testified that he had asked Mr. Boatright if he had HIV and he denied it. He made the efforts prior to engaging in sexual relations with Mr. Boatright to take the steps that are necessary to ensure that he did not contract this infectious disease, and Mr. Boatright was evasive and unfortunately resulted in this individual contracting HIV after having intercourse with Mr. Boatright. So based on the arguments in the brief as well as the oral presentation today, if there are no questions, I would ask this
I
court.
do have one going back to the strict scrutiny test. There's no intent element in the statute, right? Under strict scrutiny, the statute has to be narrowly tailored to further the interest. I guess my thoughts were that the statute doesn't require the defendant, I'll say for this purpose, have an intent to cause or to transmit the infection.
Right.
So it seems to me like it's penalizing more the sexual act itself as opposed to any intent to cause harm.
Because this statute requires that, one, you know that you have the virus that causes AIDS, and then two, that you knowingly have intercourse with somebody else without telling them. That is the reason why that act is prevented. So whether or not you intend to give that person HIV, the person who is having sex with someone who's HIV positive, they're the ones that should have that decision. So whether or not, so let's say you have an individual, they have HIV, they know they have HIV. They're gonna have sex with somebody else and they don't tell them. Whether or not their plan is to, in fact, transmit that disease is really irrelevant, because there's a high likelihood that if they engage in sexual activity unprotected, that they
But
will
what if
transmit
What
it.
if the person who hadn't used a condom, which would protect against the transmission of that?
To some degree, so the fact is that the victim, or the person who's having sex, whatever, word you want to use to characterize, that person who's having intercourse with somebody else should have the right to know whether the person they're having sex with has HIV, if that person has been tested. And then they should be able to make that decision, because there is, while a condom may increase the likelihood that you don't actually transmit it, it's not, 100%
It's almost like an
guaranteed.
informed consent type.
It is.
Thank you.
Thank you, Your Honors.
Thank you. Thank you.
Go ahead.
We have about
Just a couple
2.5
quick.
minutes left.
Okay, for purposes of the oral argument today, Mr. Boatright has always contended he did not know he had the HIV virus. I'm not going to waste any more time because that's set forth in the brief.
Yeah, you've argued that.
Okay, well, the point that I guess I would focus on in my remaining time is this. I guess it would be easy for the court to say that the constitutionality of the statute wasn't raised in the trial court. Therefore, if you don't find plain error, that whole assignment of error goes away. My concern is that there's a case pending in the Supreme Court, the State v. Batista course, that what if they do find this statute is unconstitutional? Because if you look back to the effective date of the statute, it was March 23rd of the year 2000. That's almost 17 years ago. And this is one of those intersections of medical advancements and technology and the law. And in this particular situation, as I indicated, that when HIV was diagnosed, it actually was first recognized in 1966, but it wasn't until 1981 that it was really a focus of national attention. If you recall, in 1991, Magic Johnson came out, said he was HIV positive. That was, what, 26 years ago or something like that, and he's still, with us. Unfortunately, people like Liberace, Rock Hudson, people like that, they all passed away real quick after they were diagnosed with the disease. And I guess my point is, I would hope that the court would consider that this statute may be outdated at this point in time, and it may be necessary for the court to at least, I don't know if what the Ninth District considers the Ohio Supreme Court pending case. I don't know if you delay issuing a decision in this case until the Ohio Supreme Court ruled on the constitutionality of it or not. But I would hate to see you just outright decline the constitutionality arguments and later find out 6 months or a year from now that the Ohio Supreme Court says this statute is unconstitutional. That's my greatest fear and concern, is that Mr. Boatright may fall through the cracks. So, all right.
Okay, counsel, thank you
Thank
very
you.
much. Thank you for your arguments presented to the court today. We will take the matter under advisement and issue a written opinion that will be sent to both sides. Counsel is aware, I know,